Peter, you look more official than we do, I think. So.
Well, there's a Bitmoji that looks just like this image. I was saying to the others, this is a first for me. I've never just sat in a courtroom by myself.
Right.
At least since I did telephonics in Superior Court.
Yeah, exactly. Morning, counsel. How are you?
Good morning, Judge.
Morning, Your Honor.
Good morning. We're a little bit early, but let me ask you something I was never able to do when I was in trial court. Are you folks ready to proceed? Are you waiting for clients? Are we ready to go whenever we can move?
I am ready to proceed.
Okay. Let me look to my colleagues. Judge Swan, Judge Howe, are we ready to proceed?
Indeed.
Yeah.
All right. We are here. We will then proceed. We are here for oral argument in our case, CV19 0407 FC Markey versus Markey. Counsel, each side does have 20 minutes for presentation oral argument. I will be keeping track of time manually, but you'll need to keep track of your time as well. Mr. Arpad, if you wish to reserve some time for rebuttal, you're free to do that, but you'll need to keep track of your own time as well. We have conference the case. We are familiar with the record. We'd encourage you to keep that in mind as you present oral argument. And we are being recorded here as we go along. This is sort of a new world for us, so if for some reason we get cut off, we'll please try to join back in. We're hoping that doesn't happen. And if for some reason on occasion we have sort of reverb or echo that affects what we're doing, we will try to mute so your presentations are not interrupted. But with that, Mr. Arpad, you may proceed.
Thank you, Your Honor. May it please the court. This is my first time doing this by video. It's my first time really doing much of anything by video. So I apologize if I've forgotten to mute something somewhere in the house or if the dogs interrupt. I'd like to reserve 5 minutes for rebuttal or maybe more if I could. Frankly, in looking at the briefs, I think we've made our case for the most part. There are a couple of items I'm going to highlight, but unless you have a lot of questions for me, I may end up speaking for less than 15 minutes. The one thing that really struck me in looking back at the record over this case was the judge's own assessment, where in the September 25th, 2018 hearing, he says it certainly has been a contentious case up to that point, but he says he doesn't see any reason why he's going to need to award attorney's fees to anybody at that point. Come the February hearing, where he's very upset at Mr. Markey, he says to Mr. Markey, I think it's on page, what is it? He says to Mr. Markey, it's quoted a couple of times in our brief, Mr. Markey, I don't understand your conduct for the past month or more. And that's a big chunk of what this case is about, frankly. The post-trial motion really is almost just a cherry on top, because at some point, at the latest, at the post-trial motion, the judge should have realized there was a problem here. Mr. Markey was having significant difficulties participating in the hearing. He starts out with some permanent disabilities, and he has significantly more disabilities by the time of the hearing. Now, you haven't got a full record on that. It's not like we had a hearing about his medications or about anything. All we had was a post-trial motion that says, hey, wait a minute, there was a problem here, and that attaches a doctor's note.
By counsel, right?
He was represented by counsel, and I think you can, again, we haven't had a hearing on whether his representation was sufficient, and I'm not sure, we certainly haven't presented it as our first argument on appeal, because that's not what the record covers. But he was represented by counsel, and clearly there was a disconnect between the client and the counsel. Mr. Markey keeps.
But we don't have an ineffective assistance of counsel doctrine in family court. So I'm struggling to see why the presence of counsel during the entry of the agreement doesn't end the issue.
I don't see how it could possibly end the issue. He has to at least be able to participate and assist his counsel. I mean, he's the one who gets forced into a decision here by fairly extreme pressure from the judge.
Are you suggesting that he would have failed a Rule 11 exam in criminal court?
I don't practice in criminal court, so I can't pretend to give an opinion on that.
You just sort of gave the criminal competency standard, so I thought you were making an analogy.
Yes, we talked about a number of analogies here. I think there are open questions about how competent he was. His doctor said she thought he was not competent on February 26th. And
you have that in the record?
Yes, the doctor's note says I saw him on February 26th and he was in terrible shape.
But that's different. That's different, isn't it, than being competent to make legal determinations?
There are a very wide range of possible outcomes for this, and I don't think you can decide which outcome is the correct outcome in this record. I think what we've presented here is a reason why he has to have a chance to go back to Superior Court and make that record, because I practice in probate court a fair amount. There are a wide range of things that a judge in Arizona Superior Court can do to assist somebody who's having trouble. It's not just a question of he was either so incompetent that he could not enter a contract or he stuck with the contract. There are a lot of things that could have been, and I think should have been done in this case, to ensure that Mr. Markey was receiving his due process. And the very least of them would...
I understand that, but there's no guardian ad litem, there's no conservatorship, there's no guardianship, there was no sort of suggestion by his counsel at trial, hey, I have a concern here, this can't go forward. I mean, none of that happened here.
Honestly, I do not know why his counsel did not have some kind of a concern. It frankly appears that his counsel is almost going over to the other side at some points during that last hearing, and I would ask you to look at it carefully. I'd ask you to particularly look at the pages in the 50s, where Mr. Markey is able to give clear answers about individual things, but then when the judge asks him to try and make a kind of a summary, to try and put everything together into a big picture, that's where he struggles. I'll tell you personally, from dealing with Mr. Markey without waiving attorney-client privilege, that is kind of the nature of his baseline functioning. Now, above and beyond that, he said that he's got a severe fentanyl overdose at this time, which frankly very well could have put him completely out of commission as far as being able to make a legal decision. I think he's entitled to a hearing on that, and he didn't get it.
If he had signed a contract to rent a freezer, right, would he be able to get out of it based on this argument?
That is one piece of the argument. It's not the one that we focused on. So, for example, he did, in fact, buy a house around that time.
Okay, so if he's competent to buy a house, he's not competent to make an agreement with counsel sitting by his side that a judge finds fair and equitable? I mean, that seems to fall on the wrong side of the spectrum.
Your Honor, what I'm saying is about the house is that if either Mr. Markey or the seller were dissatisfied with the argument, they could come into court and make that argument. And I don't know whether it comes out in whose favor that...
house. I mean, he bought the house, didn't try to rescind that purchase, right?
No, he didn't. He needed a house to live in.
Right, so he likes that deal, and he doesn't like this deal, but I don't see where legally he was incapable. If he's capable of doing a real estate transaction, then acknowledging what his counsel says to the court, having conferred with him, and the court finding it fair and just, it's very hard for me to find that he was prejudiced by any disability.
Your Honor, I think those are completely apples and oranges. What I'm saying about the house is it may very well be that if there was a court case about the house, it would come out that he wasn't capable of signing that contract on that day.
So he's
I don't know. It will never come.
Charged of responsibility then for making his mortgage payments, in your view, because anytime he stops, he can just say, no, I wasn't competent to sign that promissory note.
That does not happen unless somebody brings a court case about it, and nobody's doing that.
Okay, but your position is that if he were to do that, this same argument, it seems to me, would also exculpate him from his promissory note.
Anyone could make that argument, but the point that I think was very important in the briefs is that that's the most extreme version of the argument. There are a wide range of other types of relief that he could receive, and starting with just a continuance of the hearing while he got his mind together. And I will tell you, even his just baseline disability would have made it very, very difficult for him to make a decision in that type of situation. When you add in all of the medication problems, I think it's a slam dunk that he did not get a fair chance to present his case on February 28th, 2019.
Has a legal malpractice case been filed?
A legal malpractice has not been filed, and I'm not a malpractice lawyer, but normally I would not expect that to happen until we find out whether he's in fact been harmed. If he gets some type of relief in this case, then maybe there is no damage.
No, that's
or
fair
maybe
enough.
the damage is limited to attorney's fees he's incurred, something like that.
Counsel, on review, we apply the abuse of discretion standards, and the three of us were not at the hearing, and the trial judge was. And how can we say, not being there with what we have in the record, that the court abused its discretion?
Two answers to that. First of all, I think that the court never made any clear decision other than simply summarily dismissing the post-trial motion, and I think it had a duty to do more than that. And so failing to exercise discretion in any meaningful way is an abuse of discretion. We've cited you a case on that. Second, I think it jumps off the page at you that Mr. Markey, first, at least two pieces of it, okay? First, Mr. Markey has raised a more than colorable claim, and he's clearly proven a baseline disability plus some other level of disability that he's got a more than colorable claim on. Second, throughout the hearing, the trial judge is putting outrageously unfair pressure on him on things where the trial judge frankly was wrong. The whole situation leading up to the sale, take a look at that calendar. Take a look at how things go. Mr. Markey is told he has to be out by March 4th. And so his biggest concern is he's going to get in trouble if he hasn't got his stuff out by March 4th.
Well, you pardon me, Counsel, are you saying that the judge was biased or otherwise acted improperly? And if there was that in the air, why didn't the counsel raise that issue?
I can't tell you why counsel did or did not do anything in this situation. Clearly, I've acknowledged there was a disconnect between my client and his counsel. That's something that may or may not have to be resolved someday in a malpractice suit or in some other type of a forum. I can't answer that question for you. What I can tell you, I'm sorry.
Please continue. Go ahead.
Yes, Your Honor. I'm sorry, I've lost my train. Judge Howe, what was the question again?
Well, we were discussing the possibility of bias or pressuring by the trial court, and that if that was present at the hearing, why counsel did not raise that issue then.
And again, I don't know why counsel didn't raise the issue, and I would not use bias as that term is technically used in appellate proceedings involving a judge, but I would say the judge was wrong, and the judge was really, really overbearing about the things that he was wrong about, and he was essentially threatening Mr. Markey, if you don't settle, you're going to be out in the street. You're not going to be able to live in the old house. You're not going to be able to close on your new house. I'm going to be hitting you with mass. Have you ever heard a judge, page 85 of the 228 transcript, Mr. Dorenzo, I'm going to ask that you file several motions for sanctions. Throws that at Mr. Markey right before sending him off to decide whether he's going to accept this so-called settlement offer or not. Again, I think this jumps off the page when you look at the totality of the circumstances. You look at the disability and the potential of the disability being severe. When you look at the conduct of the judge trying to hold my client accountable for a bunch of things that were nowhere near as clear-cut as the judge was trying to make them out to be. And then when you look at the possibility that there was a problem with counsel here as well. I mean, again, I don't think there's an ineffective assistance of counsel argument in civil court as a freestanding argument. But that was the cases that Mr. Dorenzo cited to you. They say it's not a freestanding argument. They don't say it's never a factor that you can consider in terms of whether Mr. Markey got due process.
I mean, you're making some fairly serious accusations against trial counsel. What do we have in the record to support in other words, how could we find that trial counsel changed sides, as you pointed out, or otherwise committed some gross professional misconduct?
I am definitely not asking you to make any findings of any kind, and particularly not of gross professional misconduct. I don't think this is the forum for that. A malpractice action would be the forum for that. I am asking you to look at the totality of these circumstances and exercise your...
Yeah, but you're asking us to make that finding as a predicate for a decision in your favor in this case.
At the very minimum, I am asking you to send it back for a proper hearing on this so that the Superior Court can make a decision on it and not just dismiss it summarily. There is at least enough smoke here that something has to be done. If I may, I'd like to... How much time do I have left? It's about...
I have you about 13 minutes in, so you have about 7 minutes left.
All right, let me look real quickly here. If that's all the questions you have for me for right now, I'll reserve for rebuttal.
Very well. Thank you, Mr. Arpad. Mr. Dorenzo, and I hope I'm close on pronouncing your name correctly.
Derry Enzo. Thank you, Judge.
Thank you. Please
And
proceed.
normally I would, at this point, stand and approach the podium. May I remain seated?
Counsel, let me look to my colleagues. I see no problem with that. Very well. Please proceed.
I hope you are all well and staying safe. I would like to begin with what we're here for today, and that is that doctor's note. That doctor's note that kicked this whole thing off was attached to husband's, Mr. Markey's motion for reconsideration, and it says that I saw the patient on February 26, 2019, and I recommended that that the patient receive a surrogate representative in court. We have the entire transcript of the hearing that happened 2 days later, and not once did he ever give the court an opportunity, or did he ever say, I saw a doctor 2 days ago, and the doctor is saying that I need a surrogate. Not once. And if he does not raise this issue to the trial court, he has forever waived this claim. And he never once raised it. This transcript goes on for almost 200 pages. He testified all morning long before he decided to accept the agreement to settle the matter. If he were suffering to the point where he could not understand these proceedings, he should have filed a motion to continue 2 days before this hearing. He should have had the doctor develop this letter prior to the hearing. Instead, he waited till way after the hearing. And as a matter of public policy, this is offensive, what he's trying to do. It would crumble every criminal plea agreement. A criminal could go and plead guilty if he likes the sentence, bury the conversation that he had with the doctor, and if he gets sentenced harshly, he could come back to the court or the Court of Appeals and say, oh, I have a doctor's note that I never shared with anybody, that I never told anybody about, but I was mentally incapacitated at the time I entered my change of plea.
Counsel, let me ask on that point, are you saying then that Rule 11 and restoration of competency in criminal law, where counsel is appointed to represent a defendant, is analogous to this situation?
I think yes, it is he able to understand the nature of the proceedings is what the court has to ask. And if you look at his testimony from all morning long, he has a complete, full understanding about the issues of the case. we were talking about all morning about sole and separate property versus community property, and he talked very confidently about how he bought his nuts and bolts before he got married, how he purchased many firearms prior to the marriage. He included receipts about things prior to the marriage. He never discussed it. And he had a very good opportunity to do so because, as the court may recall, there was a hearing back in January, on January 28th, 2019. And at that time, he is raising the issue of, oh, Ms. Markey cut off my insurance. And at page 33 of that, the court says, that he is allowed, he needs to get you proof of whatever damages he's claiming he suffered as a result of cutting that off. He never presented a receipt for this Dr. James. He never presented one receipt at all in the entire February 25th transcript saying that he was off medication, that he couldn't afford certain things. This was his opportunity to come into court. There could have been plenty of pretrial discovery, pre-26th discovery of, look, these are all my medical bills, this is what's happening as a result of her cutting off my insurance. This was his time to present that, and he presented nothing. And so now we go to the motion itself, because I think one of the judges were asking about whether or not the court abused its discretion. Well, the discretion it had before it was a motion for reconsideration, and a motion under Rule 83 and Rule 85. So the motion for reconsideration cannot bring up, we know this from Whitcomb, one of the cases cited in my brief, they cannot bring up new evidence, and that's exactly what they're doing. He's saying, sure, I never gave you this letter, sure, I never even talked about my doctor, but consider it now. So I think the judge was correct in saying denied with respect to the motion for reconsideration. The other two, and I think in the reply brief, it sort of concedes this and says, hey, but wait a minute, we also have a Rule 83 and a Rule 85 we have to look at. But then we look again at the motion, because this is what the judge had before it and when it decided not to hold a hearing. And what it says is, and with respect to Rule 83, they only cite to 83A and B. A being the court did not properly consider or weigh all of the admitted evidence. How is it an abuse of discretion when you say, here's new evidence I want you to consider? But they're not saying and that's how they explain it. You didn't take into consideration and ignored the request to continue the trial. There was never a request to continue the trial. So there's no abuse of discretion in saying, I'm denying your request, because there was never a request to continue the trial, and there was never any evidence that the court did not properly consider. There was no evidence before the court about this on February 28th. The next thing they raise is B, which is an irregularity in the proceeding or an abuse of discretion depriving the party of a fair trial. The irregularity that they say is that the lawyer made the mistake because the lawyer failed to give the respondent a fair trial. Well, there's no explanation of how that happened. He had a fair trial. He got up on the witness stand and testified all morning. In fact, they had the direct examination of him had finished. I had just about finished my cross-examination when the lunch hour came, and so there was no new evidence coming in. He had complete discretion to talk about his mental illness, any bills he had, and he didn't. He chose, they spoke all morning very confidently, in detail. I mean, let's go into this in detail. When you look at the February 28th transcript, around the 50s that my colleague was talking about, the judge is going through each item of stuff. Because a week before, there was an appointment of a special master. The special master was supposed to sell all the community property because they couldn't agree how to divide it, and the judge said, sell it all. And unless you come to me with a list of things you say aren't community, even though at the previous trial nobody even raised that, but the judge was now saying, look, I made a mistake. I do want to be able to separate solemn separate from community. We'll have a hearing on that issue alone, but everything else that you do not identify in the list that you provide to the special master on or before this date is getting sold. What Mr. Markey did is he took that property, hid it, moved it to an undisclosed location, and when the judge said to him, can the special master go over to your new house and take it? And he said, no, that's my privacy. You're not taking that property. Judge, you can go over there and only you can go over there. So yeah, there was reasons the judge was getting frustrated with him. But it certainly wasn't, there was no irregularity. So the final thing is rule, and question even if rule 83 applies. They were not asking to alter or amend the judgment. Rule 83 is not even appropriate in this situation because what they were asking for is under Rule 69, void my agreement, and they never even made that argument. And then so we get to Rule 85, and the only thing that they're alleging under Rule 85, if you look at page 5 of the motion that was before the court, it was a mistake of counsel not to continue this trial. They're alleging ineffective, which is not appropriate in family law case. So the judge did not have to have a hearing because the court was there. The court saw. He responded very appropriately. So now we move to the next issue of whether or not the judge was clearly wrong. The judge was not clearly wrong. The cases cited by counsel in his reply brief regarding pressure being put on a judge all relate to cases where the judge is saying, unless you settle this, I'm fining somebody, or I'm sanctioning somebody, or I'm giving attorney's fees because you're not playing ball and settling. This judge was actually very kind. He was saying, you have your choice. I'm not forcing you to settle. But because you moved this property, I may have to fine attorney's fees. I may have to sanction you. I don't think he was being overbearing. If you read the transcript, he was being actually very polite with Mr. Markey in explaining the problems that the hole that he had dug himself into the week before the hearing took place, when you basically stole all the community property and moved it off-site so that nobody could inventory it, prevented the special master from having access to it, took a lockbox off his door so that the special master, who was the real estate agent as well, couldn't get into it. Kind of like your question about renting a freezer. He was very concerned about the purchase of that house. There was a long discussion on that February 28th hearing regarding, I need to go in, I need the money now. And the court was saying, look, if we have to continue this hearing because you want to continue the hearing, I'm going to have to do many, many things. We're going to have to continue it, meaning he wasn't going to get his money. He was going to have to return the property the next day. He didn't want that. He was going to have to, the idea, there was a discussion on the record whether or not the people who moved the property made a list of the things that they moved. And he didn't know how to go into the list. The judge was saying, I'd like to hear from them. The judge was saying, I'd like to hear from the special master. So all of these things, Mr. Markey, that's not pressure. That's real life. That happens every day in courtrooms. If you do things bad, you may have to be held accountable. And the judge was saying, you may have to be held accountable. So not only was the judge not clearly wrong, he was clearly in violation of the order that is part of the court file, the order appointing the special master, which says that all household goods were to be sold by the special master. He was not overbearing. So I don't believe that the court needed to have a hearing. The court had enough facts in front of it to establish that that there was no basis. And getting back to your question, which I guess we started off, do we have any evidence at all that he was not able to understand the nature of these proceedings? Again, looking at that transcript, the only time he ever said anything was, oh, I would like to talk to my brother. And what did the judge do? Took an hour-and-a-half break, allowed him to talk to his brother. Mr. Mull says on the record, we're going to call his brother. And he had a lawyer. Let's just be clear on this too. At no point did I believe that Mr. Moe committed malpractice. The judge was calling Mr. Markey out on his unreasonable position about the retirement accounts. And Mr. Moe had to agree with him because it was an unreasonable position. He was calling Mr. Markey out on his unreasonable position on spousal maintenance. And so, and of course, the court is allowed to impose attorney's fees for taking unreasonable positions. And we waived attorney's fees in return for the agreement that we had made. And of course, there was again an opportunity for Mr. Markey to say something, to stand up. But the court went through. Right prior to the agreement, are you voluntarily entering this agreement? He said yes. Has anyone forced you? Are you coerced? He said no. Do you believe you have sufficient knowledge of the facts? Yes. At any of those points, Mr. Markey himself, not his attorney, let's say his attorney knew about the doctor's note, which there's no evidence of, but let's say he did and said nothing. Mr. Markey had an obligation before he entered that agreement to stand up and say, hey, I just saw a doctor 2 days ago. I can't make this decision without bringing somebody else in. So none of that happened. I'd like to use my last 5 minutes to discuss the second part of this. And the second part of this is not the Rule 69 portion of it, but in this case, there were two parts of it. There was the part that the parties agreed to, that he's trying to get out of because of this doctor's note, and then there was also a portion that the court had, that the parties left for the court to rule on, and the appellate brief also says, well, he got that wrong too. So I'd like to quickly go over those. And those begin with the mortgage payments. I think there's one before that. Okay, the retirement accounts. Mr. Markey says that the judge made a mistake in two ways because of the retirement accounts. One was clearly an error, and the court very easily dismissed his bogus argument, citing to Flowers versus Flowers, because it's abundantly clear that insurance disability claims are community, and he wanted to argue that insurance disability claims weren't sold and separate, and the judge cut him off on that. The second thing he's arguing is, well, I had some money in my retirement before I got married, but he had no proof of that. He had no statements. He had no evidence of that. The week before the September trial, he disclosed some accountant's statement saying, I've extrapolated backwards from 1999 backwards, and I have estimating that this is what it could be. I objected on the record as a judge. An expert was never disclosed in this case. I don't have an opportunity to look at what their expert is coming up with. I don't know what numbers the expert came up with. And yet, Mr. Moe said to Mr. Markey, well, how much do you think you had in the account before the marriage? And he was reading directly from the exhibit that was not allowed, and the judge on the record clearly says, I'll give that testimony the weight it deserves. So it's not clear error that the judge found that he did not prove that there was a sole and separate portion of his retirement account. There was just no evidence that there was a sole and separate portion of that retirement account on the record. So it was not improper. The mortgage payments. The appeal says that the judge made a mistake about the mortgage payments, that he must have only gone to September in calculating 11 months, and this trial was continued until February, so he should have gone to February. That's not what happened. What happened was, and you have this transcript too, at the February 27th, 2018 hearing, about 11 months prior, that's when on page 5, Mr. Markey agreed to pay the monthly mortgage payments. That's what started it. So the judge got it right when he did only 11 months because he calculated the mortgage payments from the date of the order, not the date of the separation, because Mr. Markey didn't come in December or November of the previous year asking for temporary orders. The temporary go to jury was in February. So that's correct. Other community bills, it didn't even, you know, the pretrial statement has to control. Nobody brought up homeowners association fees, and we could have rebutted that had it come up. This is all new. As for the Israel attorney's fees, I think I've cited that in my brief. The court had before it Exhibit 305. 305 clearly shows from Israel, and which is a law firm that the parties were paying off. They submitted a statement, and it was clear from Exhibit 305 that it totaled $6,225. Where the $7,525 comes from is still anyone's guess. It may come from another exhibit that really was admitted through Ms. Markey, not Mr. Markey. Mr. Markey never testified that he paid $7,525. He never even disclosed his bank statements throughout this whole thing. He tried to hide them all from us and then come in and make arguments. For all of these reasons, I believe that attorney's fees are appropriate in this case. I believe that this appeal is frivolous. It is not, again, costing Ms. Markey more attorney's fees for making an argument that he never even made to the trial court. So we're asking that this appeal be dismissed and that Ms. Markey get her attorney's fees. Thank you.
Thank you, counsel. Mr. Arpad, rebuttal, you have about 7 minutes.
Thank you, Your Honor. Where to begin? I think we have documented pretty extensively that a lot of the things that Mr. Dorenzo is saying here are not true. His characterizations of what happened with saying that Mr. Markey was hiding all of the property and was not going to allow the special master to see it, that simply isn't supported by the record. We've documented that pretty extensively in the briefing. Same thing with the final arguments. Those only amount to a few $1,000s, so I don't want to spend a lot of time focusing on them. But we've cited you the evidence why we think that's wrong. I think it's pretty clear cut. And they are not waived. They are all things where we've cited to you where the judge says this is still on the table, or one thing or another they had previously come up and needed to be decided, which is why the judge decided them. With regard to the ineffective assistance of counsel, again, the cases that Mr. Dorenzo has cited to you primarily say that ineffective assistance of counsel is not a freestanding argument that you can make in civil court, and I accept that. But it is a reason why ineffective assistance of counsel is probably the wrong word because it's a doctrine that doesn't apply, but there's just no question in the record. Mr. Markey's counsel, Mr. Markey is sitting there saying, I can't function, my head is spinning, I can't think, and his counsel didn't say, I need a continuance. There's clearly a big disconnect there.
Sir, he's also sitting there saying very specific things about parts of the community estate. I mean, he did engage with the court.
Yes, there's no question he's capable of engaging. And frankly, my experience with him is that he goes into tremendous detail about things like that and is very focused on specific facts. And all of his difficulties are in integrating those things and drawing ultimate conclusions and being able to make a big picture decision, 30,000-foot type decision. And that's exactly what
intellectual parsing of various litigants, isn't it? I mean, we don't evaluate everybody's higher reasoning processes before we allow them to make a voluntary agreement. If we did, the entire economy would collapse.
Again, that is an argument that certainly can be made in terms of whether of the specific narrow piece of this case as to whether the contract portion of it should be reversed because Mr. Markey was so disabled that he couldn't enter a contract. But there's a whole other section about whether he got due process and whether he got a fair hearing and whether he needed some assistance or at least a continuance on February 28th, 2019 that also has to be addressed. And I think he at least should be entitled to go back to the Superior Court and make that case in some detail as to why he thinks he didn't get a fair trial.
And counsel, is that because in your view, counsel wasn't adequate?
there is something going on there. I can't, first of all, I'm not a malpractice attorney. I can't give a standard of care opinion about what goes on in Prescott Family Court. I've never practiced in Prescott Family Court, so I'm not going to testify about that. But there certainly is something going on there that justifies a further look so that a judge can decide whether that is one of the factors that prevented Mr. Markey from getting a fair trial.
Are you suggesting that things go differently in Yavapai County? It's a Superior Court of Arizona.
My understanding, again, Your Honor, I am not a malpractice attorney, but my understanding is that standard of care usually has to be supported by somebody who is familiar with the particular court and the practice in that community, yes. Again, it's not an issue here because this is not the malpractice case. I can't give that testimony. I can tell you there is plenty of smoke here that says that this needs to go back and be looked into. That, I think, is overwhelmingly clear.
Well, counsel, to the extent that your client suffered some financial things that he claims he should not have, could he not be made whole by a subsequent malpractice claim?
If this court decides that this trial was just fine and that there's nothing wrong with it and therefore it does not need to be looked into any further, then yes, I guess that's his remedy. I don't think that's the appropriate remedy. I think the appropriate remedy is to go back and open this up and make a fair decision. In terms of the post-trial motion, the post-trial motion focused much more than I did on pointing the finger at counsel. And if this goes back for a hearing on the post-trial motion, I don't know what strategy trial counsel is going to take. But I do want to point out that if this were a heavily litigated civil case, somebody might make the argument that this doctor's note was not admissible. But in fact, the rules of evidence had been waived in these proceedings, and so that's not something I think you should hang your decision on. It's the type of thing that would have been admitted in the primary hearing if, in fact, Mr. Markey had been able to articulate more than he did in the multiple times that he said he was having problems and couldn't function. It's a thing he would have been able to admit. I also want to, with the last of my time, focus on this timeline because it really is a crisis situation for Mr. Markey. It's April 22nd was supposed to be the hearing where they decided what they were going to do with the personal property. Mr. Markey scheduled his movers for after that hearing. Even if that happened, that's a very tight timeline for him to try to get out by March 4th. The April 22nd hearing did not happen through nobody's fault because of a snowstorm. So the new hearing gets set at 4:45 p.m. if you go and look at the minute entry on April 25th. Mr. Markey, I don't believe, even heard about it until the day before the hearing. So saying that he should have gone and made an extensive record about what to do at the hearing, it's just not realistic. He has no time to prepare for this, and the whole point of the case is that he's under this disability where he can't necessarily make an optimal decision even if he had time. It's an extremely difficult and unique situation. And when you look at all of these factors, I just think this is a situation where he at least is entitled to make his case in some detail to a trial judge that he should be relieved from this judgment.
Counsel, we appreciate your arguments today. We appreciate your briefing. We'll take the matter under advisement and we'll issue a written ruling in due course. We stand adjourned. Take care.
Thank you, Your Honor.
Thank you.